the rights of daughters as co-partners, whether such right is real or illusory. In order to correctly go to understand what the subject is, it is necessary first to go to the background of this uh, lecture. Prior to 1933, a daughter had absolutely no rights in the coparcenary property. And in 1933, an amendment was introduced in the old state of Mysore in 1933, by which certain rights were given to females on succession in respect of property belonging to a male Hindu who died intestate. Under that particular law, the son, grandson, and great grandson, they would get the property of the person who died in the first instance. In the absence of the male issues, the property would go to the mother, that is his widow. And if both these heirs are absent, then the property would go to the daughter. So therefore, the daughter would get a right on succession to the father, on failure of the male issues, and also the widow. Then certain provisions were made in regard to co-partnership property. That provision was the unmarried daughters and certain classes of females were given a small portion in the co-partnership property only at a partition in the family. They could not enforce their right at a partition. All that they were entitled to was, if the male heirs, if the male co-partners divided the property amongst themselves, then they would be entitled to a small share in the co-partnership property. Then a major change occurred in the year 1956 with the advent of the Hindu Succession Act. Uh, by virtue of Section 6, the Hindu Succession Act imagined a notional partition on the date when a person who had a share in the co-partnership property died. And whatever share that he was entitled to would be worked out. And the sons, the daughters, the wife, and the mother, and all these people would get a share in the share of the father. To give a small example, if a father had two sons and a daughter, then on and he had a share in the co-partnership properties. In the co-partnership properties would be deemed to have divided on the date of his death, at which he would be entitled to a one-third share in the co-partnership properties, because he is entitled to a one-third share, and the two sons would also be entitled to a one-third share each. And the one-third share of the father would again go to the heirs of the mentioned in clause 1 of the Schedule 2 Hindu Succession Act. Therefore, the clause 1 heirs would be the two sons, the daughter, the wife, and the mother. So, therefore, 5 people would be class 1 heirs. So, and this one-third share would be again divided amongst these 5 people, each person getting a 1/5 share, 1/15th share in the co-partnership properties. Therefore, this daughter would get a 1/15th share along, and the mother and the wife also would get a 1/15th share. But the sons would get a lion's share. They would get a one-third share plus 1/15th share. This is what happened in the year 1956. Later, an amendment was brought to the Hindu Succession Act by introducing new section 6 for the replacing the old section 6 of the Hindu Succession Act. Under this provision, the daughter was given the status of a co-partner along with the son. So therefore, the daughter also became a co-partner, and the condition to be satisfied in accordance with Vidita Sharma's case was that this daughter should be alive on the date when the act came into force on 9/9/2005. So if the daughter is alive on 9/9/2005, irrespective of the date of birth of the daughter, she would be deemed to be a co-partner along with the sons. And therefore, she would be entitled to all rights and all obligations on par with a son. That is what the 2005 Act prescribed. Then we will, the most important thing is, see, there may be a coparcenary. The coparcenary may consist of the males and the females, but there must be coparcenary property. In fact, on this question, not much significance is attached by the courts and also by the parliament. There was, if property is acquired by the father on succession to his father, under the old Hindu law, that property acquired by the father by inheritance from his father, that is the grandfather, would be ancestral in his hands, and therefore his son, the grandson, would be entitled to a share as a co-partner. Now, because the daughter is also given the status of a co-partner, the daughter also would get an equal right like a son. That is, if the father had a son and a daughter, let us suppose his father has a son and a daughter, and a mother and a wife. In such a situation, there would be a notional partition on the date of death of the father, in which the daughter would be entitled to a one-third share, the son would be entitled to a one-third share, and the father, on the date of his death, would be entitled to a one-third share. That one-third share is again shared by all persons who are in class 1 of the schedule, that is the daughter, the son, the mother, and the wife. So therefore, each of these people get a 1/12 share. Therefore, the daughter and the son, they get a one-third plus 1/12 share, and the mother and the wife or the widow would get a 1/12 share each. This is what would happen after the 2005 amendment. The most important factor is a daughter may be a member of the coparcenary. If coparcenary property is in existence, then only she would be entitled to a right on par with a son. If by interpretation of various sections of the Hindu Succession Act, if there is no coparcenary property at all, then the rights given under Section 6, amended Section 6 of the Hindu Succession Act, would not benefit either the daughter or the son. If there is a treasure, it can be shared equally by the father, by the son and the daughter. If there is no treasure at all to be shared by the co-partners, then the rights given are only academic and they have no value at all otherwise. In order to understand this question, the first point that I would like to take in for consideration is this. While interpreting section 8 of the Hindu Succession Act, the the Supreme Court, in a case reported in AIR 1986 Supreme Court 1753, that is, yeah, in that is popularly called as Chandrasen's case. In that case, the Supreme Court said that if there is a property belonging to the grandfather, which is his self-acquired property, and if the grandfather dies after the commencement of the Hindu Succession Act, and the property is inherited by his son, the father, under Section 8 of the Hindu Succession Act, the property in the hands of the son would be self-acquired property, and the grandson would not be entitled to any share in this property. Therefore, let us suppose the grandfather earned the properties even prior to 1956. They were his self-acquired properties. He died after 1956. Then the property in the hands of the father would be self-acquired property in his hands. And therefore, the grandson has no right by birth in this property, and therefore he cannot file a suit and ask for a partition of any share in the coparcenary in the properties that was originally acquired by the grandfather. If the grandfather had died prior to 1956, the law would have been different. If he had died prior to 1956, then what would happen is, the under the old law, any property acquired by the father on succession to his father would be coparcenary property in the hands of his father, and therefore his children, either a male or female, would get a right by birth in this property if the father should die after the 1956 Act. So, therefore, the death of the grandfather must be prior to 1956. If the grandfather died after 1956, then Section 8 would apply, and the property in the hands of the father would be his self-acquired property. Only if the death was prior to the Hindu Succession Act, then the property in the hands of the father would be coparcenary property, and the granddaughter or the grandson would be entitled to an equal share as a coparcener. In fact, the law prior to 1956 was that under Hindu law, the moment a son is born, he gets a share in the father's property and becomes part of the coparcenary. His right accrues to him not on the death of the father or inheritance from the father, but with the very fact of his birth. Normally, therefore, whenever the father gets a property from whatever source, from the grandfather or from any other source, be it separate property or not, his son would have a share in that property, and it will become part of the joint Hindu family, and his son and grandson and other members who form part of the joint family with him. In fact, this was the position prior to the Hindu Succession Act. By virtue of Section 8 of the Hindu Succession Act, the position is changed. The Supreme Court has said that under Section 6, it is only the son who is heir in class 1. The grandson is not heir. Son of a predeceased son, son of a predeceased son of a predeceased son, they are the only class 1 heirs. Son excludes his children or grandchildren. Therefore, if the property of the father, of the grandfather, who died after 1956, is acquired by the father, it would be the self-acquired property of the grandfather, the self-acquired property of the father, and therefore the grandson or the granddaughter cannot file a suit for partition and cannot get her share determined as long as the father is alive. If the father dies without leaving a will, if the father dies without alienating the property, then only the grandsons would get a right by birth. There are two kinds of uh, uh, succession. One is called Apratibandadaya and the other is Pratibandadaya. Apratibandadaya means acquiring right by birth in coparcenary in some property. To the right to acquire a share in the property does not depend upon the father being alive or the grandfather being alive. It merely because the co-partner takes birth in the family, by reason of the birth, he gets a share in the property. His share does not depend upon the father being alive or dead. So therefore, this is the right to succession does not depend upon the death of any other person, and a person acquires a right to birth, right to property by virtue of his birth. That is called apratibandadaya. Sapratibandadaya is application of section 8. Property belongs to the grandfather. That would be his self-acquired property. And that the father is the exclusive owner of the property as long as he is alive. And only on the death of the father, if he does not write a will, if he does not alienate the properties, then only the children would get a right in those properties. That is called Sapratibandadaya. So therefore, the rights under section 8 is Apratibandadaya. Under section 6 is Apratibandadaya. The rights acquired by inheritance under section 8 would be Sapratibandadaya. So therefore, if whatever property might have been acquired by grandfather or father after 1956, all those properties would be self-acquired properties in the hands of the father, and therefore the grandson would not get a right by birth. In order to give a very simple illustration, I would say the father has acquired a few properties from his grandfather who died after 1956. Those properties would be self-acquired properties in the hands of the father. Let us suppose the father dies. If the father dies, the property would devolve upon his sons and daughters in equal shares. And the sons and daughters in such a situation would take the property as tenants in common and not as joint tenants. If they take the property as tenants in common, it would be their self-acquired property and it would not partake the character of co-partnership properties. Therefore, in such a situation, the property in the hands of the father would be his self-acquired property, though the same is acquired by him from his father or grandfather who died after 1956. So therefore, the grandchildren also get these properties as their self-acquired properties. And therefore, whatever succession that may take place subsequently, all persons inherit the properties not as joint tenants but as tenants in common. And therefore, all these properties will be self-acquired properties. In fact, I find that large number of suits are filed. Everybody thinks that a daughter as a co-partner would be entitled to a share in the grandfather's property. In fact, in one of the cases which I am handling, I would say the property was allotted to the grandfather by virtue of a grant made by the government. The grandfather died in 1986 after the advent of the Hindu Succession Act. The property devolved upon his two sons and a daughter and and specific properties were allotted to all these three persons. When specific properties were allotted to all these three persons, then the one of the one granddaughter filed a suit for partition, saying that the property allotted to the share of her father at a partition between the three children would be joint family proprietary property in the hands of the father. Therefore, I am entitled to a share. In this case, the daughter would not be entitled to a share at all, because the property was the self-acquired property of the father. He died, and the property in the hands of the father acquired the character of self-acquired properties. Therefore, as long as the father is alive, the daughter cannot claim a right in this property. And if the father sells the property, the daughter cannot question the alienation made by the father. Therefore, such plaints can be easily rejected under Order 7, Rule 11 CPC. So, in fact, in Chandrasen's case, after referring to the law prior to 1956, this is what the court has observed. The court observed that this position, that is what the position that existed prior to 1956, this position has been affected by Section 8 of the Hindu Succession Act 1956. And therefore, after the act, when the son inherited the property, in the situation contemplated in Section 8, he does not take it as karta of his own undivided family, but takes it in his individual capacity. As stated above, after the coming into force of the Hindu Succession Act 1956, self-acquired or separate property of male Hindu on his dying intestate devolves on his heirs in their individual capacity and not as co-personal property. And in such a case, their children, that is the grandchildren, will not acquire any right by birth in such property. So therefore, the old notion of the property acquired, either acquired by the father or grandfather, would become co-personal property, is completely given a go by this decision of the Supreme Court, and this principle has got to be clearly kept in mind. In fact, this principle of the Supreme Court is followed in 1987 Supreme Court 558 Yudhishthir versus Ashok Kumar. In fact, they refer to the earlier Chandrasen's case and affirm the sale with approval. That is Commissioner of Wealth Tax Kanpur versus Chandrasen. It is quoted with approval, and this is how it, to a similar effect, is the observation of the learned author of Mains Hindu Law, 12th edition, page 919. In that view of the matter, it would be difficult to hold that property which devolves on a Hindu under Section 8 of the Hindu Succession Act would be HUF in the hands vis-a-vis his son. If that be the position, then the property which devolved upon the father of the respondent in the instant case on the demise of his grandfather could not be said to be Hindu joint family property. Then there is another case in which the Supreme Court has also affirmed this position again. That is AIR 2008 Supreme Court 1490 Banwar Singh versus Puran. In this case also they hold that the property acquired on succession to the grandfather by the father on inheritance would be self-acquired property in these hands. And the latest decision affirming the same principle is a decision reported in 2019 S.R. Civil, page 809, that is Ashrur Singh versus Harpal Kaur and others. In this decision, para 7.5 may be referred. wherein it is clearly stated, after the Hindu Succession Act 1956 came into force, this position has undergone a change post 1956. What's important? Post 1956. If a person inherits self acquired property of his paternal ancestor, said property becomes his self acquired property and does not remain coparcenary property. In fact, in spite of the decision in Chandrasen's case, a mistake was made by the Karnataka High Court in a decision of the High Court in Mallika versus Chandrappa. In fact, the court ruled that though the succession opened to the grandfather after 1956, the court held that the property in the hands of the father was coparcenary property in view of the old law in existence prior to 1956. An application for review was filed before the court. The High Court has allowed the review petition by following Chandrasen's case and said, true, the law applied was prior to 1956. A mistake was made by the High Court and therefore the review petition was allowed. There is a decision reported in 2008, 1 Karnataka Law Journal, page 482, Mallika versus Chandrappa. There are two other division bench decisions of the Karnataka High Court. The next is 2015, 1 Karnataka Law Journal, page 65. In this, Radha versus Venkatappa and others, reference may be made to page 68 of the report. This is what the decision says. Therefore, the short question is, if the first defendant has succeeded to the self-acquired property of his father, whether the property in the hands of the first defendant has to be considered as an ancestral property or a coparcenary property to allot a share to the plaintiff. Admittedly, the property in the hands of the first defendant has to be treated as self-acquired property because he has succeeded to the property after the death of his father, which was the self-acquired property of Narasimhaya. So therefore, the property was the self-acquired property of the grandfather Narasimhaya. Therefore, the property acquired by the father on succession to Narasimhaya was held to be self-acquired property, and therefore the grandson who had filed a suit for partition, the court held that he had no right and therefore dismissed the suit. Then the last decision of the Karnataka High Court, again a bench decision in 2016, 5 KCCR, page 1273, Shakuntala versus Basavaraj. This is what the High Court says. After coming into force of the Hindu Succession Act 1956, self-acquired or separate property of a male Hindu on his dying intestate devolves on his heirs in their individual capacity and not as coparcenary property. And in such a case, their children will not acquire any right by birth in such property. The trial court was right in holding that the suit property that fell to the share of the plaintiff's father were his individual and separate properties as it is in accordance with the law stated above. Therefore, the plaintiffs are not entitled to any share in the suit properties. Accordingly, the sale effected by the father of the plaintiffs in favor of defendant number 4, as per the sale deed at Exhibit D2, is not liable to be set aside. We find that the trial court was justified in holding that the plaintiffs colluded with their father, mother, and brother in filing the suit to cause loss to defendant number 4, who was the purchaser of the suit lands from the plaintiff's grandfather. Then there is another decision of the Delhi High Court reported in AIR 2008 Delhi, page 40. Grandson or granddaughter will have no share in the property left by the grandfather during the lifetime of the father. So therefore, the large chunk of co-personal properties are those which are inherited either by the father or from the grandfather. If the death of the grandfather or the father takes place subsequent to 1956, the property would not acquire the character of co-personal properties. Therefore, a large chunk of properties which were earlier co-personal properties would now be self-acquired properties. So therefore, the property in the hands of the father would be self-acquired properties. Therefore, after the death of the father, the property goes to the son. That would be self-acquired property in his hands. On his death, it goes to his son. That would be self-acquired properties in his hand. This is all a chain reaction. Therefore, this property, which originally became self-acquired property on succession, would never get converted into co-personal property. Therefore, there is no co-personal property at all by inheritance in view of these decisions of the Supreme Court and the various high courts. Then there is one question that would arise for consideration. Suppose the property is the self-acquired property of the father. The father dies. If the father dies, the his children, say 3 sons and a daughter, they continue to reside together subsequently. They acquire some more properties from the income of the properties which they inherited from their father. Then what should happen to those properties? Whether these properties jointly acquired from the income derived from the properties which they acquired on inheritance from their father, would they be joint family properties or co-personal properties? In fact, this question was considered by the Supreme Court in a decision reported in 1995 Supreme Court Cases, Volume 6, 523, P. Periswamy versus P. Perithambi, that is Civil Appeal number 667 bar 1989. In fact, in this decision, they say such property jointly acquired with the income of the property which they inherited from the father would not partake the character of joint family properties. They would be only joint properties. Then and the acquirers would be co-sharers only, and they would be tenants in common and not joint tenants. In fact, referring to a full bench decision of the Madras High Court, this is what the Supreme Court has said. In view of the interpretation put by the full bench of the Madras High Court, that the sons in such a situation would get the self-acquired property of their father by inheritance, having the status as tenants in common, they could not thus treat such properties in their hands, even though joint in enjoyment, as joint Hindu family properties. Likewise, the income derived therefrom, if employed to purchase other property, would not cloak the new acquisition with the character of joint Hindu family property, but may otherwise be joint properties. So they will only be joint properties of the acquirers, and they will never become joint family properties. And in fact, they would be only co-owners in these properties. It is further said in this decision that if the parties herein were co-owners of that property and the said property had been purchased from the income derived from joint property, then obviously the same has to be accounted for as joint property and not as joint family property. Concluding, this is what the Supreme Court has said. From what we have said above, it is plain that the property in possession of these two branches of the family sought to be partitioned was not joint family property, but the 3 sons obtained it by inheritance from their father, the last elder, and their status was that of tenants in common. If the accretions to that property had been made out of the income from joint property, then those properties were accountable as held by the High Court, but that aspect would have to be decided before passing a final order. So therefore, see, even if the sons together acquire the property, they don't become joint family property, they only become joint property. And in fact, this principle is also affirmed by the Karnataka High Court in a decision in RFA 232 bar 2000, 2000 in BP Arun Kumar versus Srimati Achala and another is a bench decision of Justice Manjula Chellur and G.C. Baroka. In this case also, they have arrived at the very same conclusion that the property acquired from their joint funds would not be joint family property, and it would be only they take the property as tenants in common, and they would be co-owners of this property by relying upon the decision of the Madras High Court. They have not made any reference to the decision in Perithambi's case. So therefore, all these classes of properties would get excluded from the class of coparcenary properties by interpretation of Section 8 of the Hindu Succession Act. Then the next question is, suppose there is coparcenary property. The coparcenary property is partitioned amongst the members of the family after 1956. Then what should happen to the properties in the hands of various persons to whom those properties are allotted? Normally, it would be thought that if coparcenary property is partitioned, if property is allotted to the shares of a few coparceners, they would be coparcenary property in their hands. That is the normal conclusion which anybody would come to. But the Supreme Court has said, by a reference to Section 19 of the Hindu Succession Act, in fact, in a number of cases, we find that Section 19 of the Hindu Succession Act is not applied with full force, and therefore a wrong conclusion is arrived at by various courts in regard to this aspect of the matter. In fact, mode of succession of 2 or more heirs. This is how Section 19 reads. If 2 or more heirs succeed together to the property of an intestate, they shall take the property subject as otherwise expressly provided in the Act, per capita, not per strips. We are not on that particular section. As tenants in common and not as joint tenants. So therefore, one has got to clearly keep in mind the distinction between tenants in common and joint tenancy. If the property belonging to them, they acquire the property as tenants in common, their share in the property is determined. The property would not go by survivorship. If the property is joint tenancy, then the survivorship would apply, and there would be chances of the shares going up and coming down. So therefore, if property is allotted to a particular party under a partition deed, that person would take the property as his self-acquired property. The property would cease to be coparcenary property. This is the interpretation given by the Supreme Court in a decision reported in AIR 2008 Supreme Court, page 2489, Hardiyo Rai versus Shakuntala Devi. In fact, it's a very, very important decision. This is what the decision says. When an intention is expressed to partition coparcenary property, the share of each one of the coparceners becomes clear. When once the share of the co-partner is determined, the property cease to be co-partnership properties. In such an event, the parties would not possess property as joint tenants, but as tenants in common. When a co-part, this is what is the most important thing which everybody should keep it in mind. When a co-partner takes a definite share in the property, he is the owner of that share, and as such, the same by sale or mortgage in the same manner as he can dispose of his separate property. So therefore, when a joint family property is divided between the sharers, and the sharers are allotted definite properties, or even if a no, if the joint status of the family is broken by virtue of division of status, even in such a situation, the Supreme Court says that the parties take the property allotted to them as their individual property and not as joint family property. And therefore, the character of the property which was co-partnership earlier would get transformed into self-acquired properties by virtue of the partition, where a co-partner takes a definite share in the property. He is the owner of that share, and as such, he can alienate the same by sale mortgage in the same manner as he can dispose of his separate property. It becomes his separate property. Then this matter is again, this question is again the subject matter of another decision of the Supreme Court reported in 2020, S.R.Civil 129, Radhabai versus Ramanarayan. In this decision, the principle laid down in 2008 Supreme Court in Hirdayorai's case is quoted with approval, and they say by operation of section 19, they take the property as tenants in common and not joint tenants. If section 19 of the Hindu Succession Act is closely read, the wordings in that section indicate that the same would be applicable in cases where there is succession of property after the Hindu Succession Act came into force. The word used in the section is succession and not inheritance. For this reason, this section applies both in cases of acquisition of joint family property at a partition or by inheritance. For this reason, where a partition takes place subsequent to 1956, even of ancestral property, the parties to the partition acquire the property in their individual capacity, and their children who are neither born nor alive on the date of the partition would not get any share in the properties which are the subject matter of the partition. This principle is affirmed by the Supreme Court in a few decisions which are referred to by me. Now, therefore, in this case before the Supreme Court, see, one Jagannath Singh died in 1973. After he died, his sons acquired the property on succession to his father. And there was a partition amongst these persons later. The grandson filed a suit for partition against the father, claiming a 1/8 share in these properties. The grandson was not born on the date when the grandfather died. So, on the date when the grandfather died, there was a notional partition. In that notional partition, the father was allotted to a particular share. The plaintiff's son was not born on that date. The father took the property as a tenant in common and not as joint tenant, and therefore the property in his hands would acquire the character of self-acquired properties. Therefore, the grandson would not get a right by birth in this property, and he cannot either challenge the alienation made by the father or claim a share in these properties during the lifetime of the father. So therefore, and this principle is also affirmed by the Supreme Court in a decision reported in 2016 Supreme Court, page 1169. It is a decision of Justice Rohington Nariman in Uttam versus Saubhag Singh. In this case, in fact, the entire principle in regard to Section 6 is summed up in the judgment. And this is what they say. This is the principle laid down, one of the principles laid down in the decision. On a conjoint reading of Section 4, Section 8, Section 19 of the Act, after joint family property has been distributed in accordance with Section 8 on the principles of intestacy, the joint family property ceases to be joint family property in the hands of various persons who have succeeded to it as they hold the property as tenants in common and not as joint tenants. In this particular case also, the grandfather died in 1973 and the plaintiff grandson was born subsequent to the death of the grandfather. Therefore, the property acquired by the father at a notional partition became his self-acquired property, and the suit by the grandson for a partition was dismissed by the Honorable Supreme Court. Then there is one recent decision of the Karnataka High Court where where a question of law is raised, but that question is not answered. In fact, this is what, in fact, in that case, what happened was that a daughter filed a suit for partition in that case. The daughter, that the property belonged to the property was joint family property. The property was divided amongst the father and his brothers and sisters. Certain properties were allotted to the father. Therefore, the High Court said, though there was a partition amongst the sons, that is, the father and his brothers, the property acquired by the father was joint family property in his hands. So that is the assumption the court makes. And after making that assumption, the court comes to the conclusion that if that property is coparcenary property, if a son is born subsequent to the partition having taken place prior to 1994, a son born would take would get a right by birth in the father's property, whereas a daughter could not challenge a partition prior to 2012, 1994, 2004, prior to 2004, because all those partitions are saved. And if a daughter is born subsequent to the partition, the daughter would not get a share because a challenge to that partition prior to the cutoff date is prohibited under the Act. Therefore, therefore, there is some these two provisions would require to be harmonized. This is what the court has said. In fact, the presumption that the court has made in this particular case, that the property which was acquired by the father at a partition would be coparcenary property in his hands, and therefore his son would get a right by birth. This is the assumption made by the court. That assumption made by the court is itself wrong. The son in such a situation would not get a right by birth. The daughter also would not get a right by birth. Therefore, there is no question of harmonizing Section 6.1 and Section 6.5 of the amended 6 of the Act. So therefore, the court has not taken into consideration that after a partition, the property allotted to the father would be self-acquired property in his hands. In fact, I will read only 2 or 3 lines in this decision. This is what he says, what the decision says. Thus, if a son is born after the partition in respect of coparcenary property, said son acquires a right in the property allotted to the share of the father. Likewise, by virtue of section 6, clause 1b, the daughter born after the partition and amendment to section 5 of 1956 will also acquire a share by birth in the family in the coparcenary property allotted to the share of the father before the birth of the daughter. However, subsection 5 of section 6 of the Act 1956 seems to make section 6(1) inapplicable in a situation covered under subsection 5 of section 6, which reads as follows: nothing contained in this section shall apply to a partition which had been effected before 20th day of December 2004. The literal interpretation seems to suggest that the daughter born to a copartner after partition, which takes place before 2004, will not have the status of deemed copartners in respect of copartnery property allotted to the share of the father. However, this is the mistake made. However, Shastric Hindu law provides that the son born to a copartner after partition will acquire a share in the copartnery property allotted to the father. To achieve this object of the enactment, there is need to harmonize section 6(1)b and section 6(5) of the Act 1956. Therefore, the Shastric Hindu law referred to by the court would apply only if a partition had taken place prior to 1956. In this case, the partition has taken place subsequent to 1956 and before 2004. Therefore, the property in the hands of the father would be his self-acquired property and not joint family or coparcenary property by by applying the principle of section 19 of the Hindu Succession Act. Therefore, the daughter born subsequently also would not get a right by birth. The son also would not get a right by birth. Therefore, there is no need for giving in a harmonious interpretation as stated by the learned judge in this decision of Prafulla M. Bhatt versus Saraswati, dated 27 January 2015, rendered by Justice Ananta Ramanatha Hegde. So, therefore, my submission is that there is no need for harmonizing these two provisions at all. So, therefore, two chunks of properties they get excluded from coparcenary property. Then there is a third chunk of property which also gets excluded from coparcenary property, and that is, see, suppose a division of status is affected amongst the members of the family, either by issue of a notice, or by filing a suit, or by expressing an unequivocal intention to separate from the family, or in some and even by a notional partition as contemplated under section 6 of the Act. Suppose some properties are acquired with the income of coparcenary properties which were in possession of a particular coparcener, and the subsequent accretions to the family properties are made with the income from coparcenary properties. The Supreme Court says when once there is a division of joint status, nobody represents the family either as manager or otherwise. The property in acquired by a member subsequent to this division of status would be his self-acquired property, and all that the other members could ask for was only an account for the income derived subsequent to the division of status, and the property acquired with the aid of joint family funds would also not be joint family property. In fact, for that position, there are two decisions of the Karnataka High Court which may be referred to. The one is 2012, 3 Karnataka Law Journal, page 422. It's a division bench decision. The Supreme Court decision is AIR 1972 Supreme Court 1279 MN Aryamurthy versus Subbaraya Shetty. Then again another decision AIR 2002 Supreme Court page 2066. So therefore a large chunk of properties that are acquired subsequent to division of status would also qualify as coparcenary properties in which any male or female coparceners would be entitled to a right by birth. So therefore, these chunks of properties also gets excluded. Therefore, then we can go to the next class of properties. That is, suppose property is acquired in the name of a female member of the family, even from the money belonging to the joint family. Let us suppose joint family has large funds. Those funds are utilized and property is purchased in the name of a female member of the family. What should be the character of these properties? The Supreme Court has said in a decision reported in 2009, S.R. Civil, page 728. In this decision, the Supreme Court has said that by application of Section 14 of the Hindu Succession Act, whenever property is registered or acquired in the name of a female, in the absence of any other evidence, would be her self-acquired property, and any member of the joint family cannot claim a right in this property, in this particular property. Going a step further, the Karnataka High Court, in a decision reported in 2015, 1 Karnataka Law Journal, page 698, has held that even if there is evidence to show that the property is acquired in the name of a female with the joint family funds, so even if there may be an admission, there may be evidence. Even in such a case, the property will be self-acquired property of the female by application of Section 14(1), and nobody can claim a share in these properties as long as the mother is alive. Then there is one recent decision of the Karnataka High Court reported in RFA 100238 bar 2017, Shivagangava alias Parvatava versus Mahadevappa Fakirappa Singli. In this case, what happened was that the coparcenary property was allotted to the share of the father, and that property was inherited by the daughter. So therefore, the mother, as coparcener, sold the property to different persons under different sale deeds. This sale was challenged by the daughters. So therefore, the alienations made by the mother were challenged by the daughters. The court said that by a close reading of Section 14(1), where property is allotted to a coparcener to a daughter coparcener under a partition, such property also becomes her exclusive property by virtue of Section 14(1) of the Act. And whatever manner in which she might have acquired the property would be self-acquired property in the hands. And his daughters, though they may be coparceners under the new Act, they would not get a right by birth in these properties and they cannot either challenge the alienations made by the mother, or they cannot challenge, they cannot claim a right in these properties as long as the mother is alive. In fact, I would like to read only one particular paragraph in the judgment where their lordships have affirmed this particular principle. In fact, uh, referring to section 14.1, this is what their lordships have said. Perusal of the said provision indicates, that is section 14 indicates, that any property possessed by a female Hindu, whether acquired before or after the commencement of the act, will be held by her as full owner. The explanation provides the manner of acquisition and makes it applicable to both movable and immovable property. The manner of acquisition covering inheritance, devise, or at a partition, or in lieu of maintenance, or arrears of maintenance, or by gift from any person, whether a relative or not, before or after her marriage, or her own skill or exertion, or by purchase, or by prescription, or in any other manner whatsoever, though through omnibus provision, though at the end of the proviso, in any manner whatsoever, would be sufficient to cover any other manner of acquisition by a female Hindu. The explanation deals with the acquisition of property at a partition. That is to say, if a female Hindu gets any right, title, interest, or property at a partition, the said property would be her absolute property with absolute rights to deal with the same. In the present case, admittedly, there being a partition between Neelava and dependents 1 to 4, one-third share of Mallappa came to Neelava. That is to say, that the acquisition of title of Neelava was under a partition which was recorded in the mutation entry. Be that as it may, looked at from any angle, the property stood in the name of Neelava, and irrespective of the manner of acquisition, in terms of section 14 of the Hindu Succession Act, the said property absolute property. Therefore, their daughters could not challenge the alienations made by the mother. Therefore, if you look at all these decisions, the it would appear as if there is only a coparcenary and there is no coparcenary property. In fact, to qualify a property as a coparcenary property, according to me, there is only one situation. That situation is that the property should have been acquired by the grandfather prior to 1956. The grandfather must have died prior to 1956. None of his sons or grandsons should have died after 1956, and there should be no partition in the family. So therefore, unless these 3 or 4 conditions are satisfied, there will be no coparcenary property at all. Therefore, for operation of section 6, there must be coparcenary property. If there is no coparcenary property at all, in view of the decisions of the Supreme Court, decisions of the Supreme Court, if a share is given to the daughter, or share is not given to the daughter or the son, it matters very little. There is no room for acquisition of section 6. Section 6 is a dead letter because there is no coparcenary property at all. Because in view of these various decisions, 99% of the property gets excluded from the ambit of coparcenary property. Therefore, it is rather difficult why we should make such great exercise in trying to understand section 6 when it has no practical application at all. And apart from that, the daughter should also be alive on 9/9/2005, irrespective of when she is born. So therefore, if in each one of the cases where a daughter files a suit for partition as a co-parcener. In fact, it would not be very difficult to meet her claim because of these various decisions of the court. In fact, at the time when Section 6 was debated in the parliament, some members should have raised an issue. What is the use of conferring the status of a co-partner on a daughter when there is no co-partner property at all? On the other hand, by amendment of Section 6, what has happened is only this. In fact, prior to 1956, a son could never have been deprived of any share in the joint family properties or co-partner properties by the father. Now, by virtue of this amendment, a daughter also cannot be deprived of his share as a co-partner in the family. See, the co-partner is there. The right can be arithmetically determined by any lawyer. But if the property is not there at all, where is there to obtain a share in the co-partner property? This point it is just like saying that there is a treasure box. In the treasure box, the son alone would get a large chunk and the daughter would get a small chunk. Now, by the change of law, it says that in the treasure box, the daughter as a co-partner is entitled to the same share. The son as a co-partner is entitled to the same share. But by opening the treasure box, nothing is contained in the treasure box. The son gets nothing, the daughter also gets nothing. And all these properties would partake the character of self-acquired properties in the hands of the father. Therefore, the father can alienate these properties without reference to his children. He can make a will of these properties without giving anything to these children. Therefore, protection to females as contemplated under Section 6 is not attained at all by virtue of amendment of Section 6A. And this is my opinion having regard to the various provisions of the Hindu law, especially Section 6, Section 8, Section 14, and Section 19. In fact, Section 19 has not been applied with proper force in many of these decisions of the courts. If many of the judgments are read, many judges, even of the higher courts, have made a mistake in not correctly understanding and apply the principle of Section 19 and have arrived at wrong conclusions also. Therefore, in my view of the matter, the rights of a daughter are not real. They are only illusory, and that is my conclusion. Thank you, Mr. Chattar. Thank you all for having given me a patient hearing.
Thank you, sir. So there's one question, though it is not in terms of the session itself. It says, is it mandatory to register a will?
I am not hearing you. I am not hearing you, Mr. Chattar.
So then that audibility issue, then we can drop it.
Right.
Right, sir.